This is one of those small claims cases that prove something simple on paper can turn into a full-blown courtroom showdown. A $6,000 roof job, a $3,000 down payment, and one critical detail that changed everything: the color of the shingles. Black was agreed upon, brown was installed. And now? We've got a $12,000 lawsuit sitting in front of a judge. But here's where it gets interesting. This isn't just about color. It's about contracts. It's about trust. It's about whether a contractor can upgrade something without permission and call it a favor. And it's about how much emotional distress is really worth when a mistake is admitted, but not corrected the way the customer wants. The plaintiffs, Mr. and Mrs. Peoples, say they were clear from day one black shingles to match their black and white home. Instead, they got what the contractor calls weathered wood. The contractor admits he made the change, but says he was trying to help. He apologizes. He offers compromises. Yet somehow they end up in court. Now the judge, and yes, this is a bench trial, meaning he alone decides the outcome, has to untangle whether this is a breach of contract, a misunderstanding, or something more. Was this a simple mistake that could have been fixed, or did this contractor cross a legal line by making a unilateral decision? Stay with us, because when the numbers start breaking down and when the pain and suffering claim hits...
We're here for a small claim suit. I did review documents that were received by the court from both parties. I have the petition, which was filed by you, Mr. and Mrs. Peoples, in regards to some work that was done to your home, some roof work. Along with the petition, I have, looks like it is an invoice, military, and as well as a copy of a cashier's check. That's all. That's what I received from you, the plaintiffs, in today's case. And the defendant, you, Mr. Alvera, you did respond in writing. I do see a letter from you in regards to the work that was done. And I just want to make sure, Mr. Alvera, did you submit a copy of this response to Mr. and Mrs. Peoples?
I think we did.
Okay. And usually in cases like this, based on, the petition and the response, I usually give, the parties the opportunity to talk amongst themselves to see if they still want to proceed on with this case. So I'll start with you, Mr. and Mrs. Peoples. Would you all still want to proceed on with this case, or would you like to meet privately with Mr. Alvera regarding this suit?
I want to proceed.
Okay.
We'll proceed.
Yeah.
Okay. All right. Okay. So with that being said, let me explain how this is going to go. You, Mr. and or Mrs. Peoples, will get the opportunity to present the case to me. This is a bench trial. So it's up to you to convince me that the defendant, Mr. Alvera, on behalf of America Roofing, owes you the amount of money that you requested in your petition. You requested $12,000 in damages. So it's going to be up to you to prove to me that he owes you $12,000 in damages.
Notice what the judge just did here, and this is important. He clearly explained the burden of proof. In small claims court, especially in a bench trial like this, the plaintiffs must prove their case. That means Mr. and Mrs. Peoples have to show not only that the wrong shingles were installed, but that this mistake legally entitles them to $12,000 in damages. And that's a big number considering the contract was for $6,000 total. Also key, the judge is making sure there are no surprise documents. Courts hate ambush evidence. Transparency matters because both sides need a fair opportunity to respond. Right now, the energy feels procedural, calm, structured. But make no mistake, once we get into what was agreed upon versus what was installed, the emotional temperature is going to rise. Here's the question for you. If a contractor upgrades your shingles but installs the wrong color, is that breach of contract or just bad communication?
That's how the case is going to go, because that's what you put on the petition. And so while you're speaking, I'm going to ask that you, Mr. Alvera, refrain from interrupting the plaintiff in their presentation. And then afterwards, I'll give you, Mr. Alvera, the opportunity to defend yourself. It'll be up to you to provide proof to me that you do not owe them $12,000 in damages. And that's kind of how the case is going to go. And while you're speaking, I'm going to ask that you, Mr. and Mrs. Peoples, refrain from interrupting Mr. Alvera. This is just to make sure I develop the facts of the case and get as much information as possible. Now, with that being said, I did go over what I received prior to today's hearing. The next thing I need to ask, is there anything that you may bring up in court that hasn't been shared with me or with the other party? And I'm going to start with you, Mr. and Mrs. Peoples.
Not that I can think of right now, Judge. Only
Okay.
thing we have is maybe, do we have a copy of when we paid the $3,000 down payment?
Okay. Is there anything else? Because you're suing for $12,000. So I'm just trying to make sure that if you had any other documents that you want to use to support your case. That's what I'm looking for.
The estimate for replacement roof from another company, what they would charge to do it, and the rest of it was just damages for personal damage.
Okay. And so the estimate, is that an email that you received, or is it just a handwritten
It's
estimate?
a handwritten receipt,
Okay.
but it's on the letterhead from the Castillo Roofing Company, on their personal letterhead, company letterhead.
And then the other part is you're saying just personal damages is what you're seeking the rest to make up the $12,000. Is that what you're saying?
Yes, plus the $3,000 that I already paid Mr. What's his name?
Alvera.
Alvera.
Okay. All right. So you have that now. Did you send a copy of that to Mr. Alvera so that he can review it?
The estimate from the other company, no.
Okay. When did you get that estimate?
It was dated July 15th of 2025.
Okay.
I got the estimate prior to deciding to go with American Roofing because they were cheaper.
Okay. So this is something that you had prior to. So okay. You have all right. I'll just hold off with you. Mr. Alvera, do you have anything other than what you provided to the court to support your defense?
Well, the only thing I can tell is, I'm gonna make a long story short.
Well, no, okay. Well, what I need, do you have any documents that you plan on using in your defense? That's what I'm looking for. Do you have any documents that you plan on using in your defense? Not testimony, but actual physical documents.
Well, the letter that I sent is the only one I have. I have, because I tried to convince them to let us either remove the shingles that they don't like and put the that they want, but they refuse. They say they want to go to court. So
we'll get into that. We'll get into it. I just wanted to make sure I had that there was a level of transparency in regards to documents. That's the key starting out. Just want to make sure that there's no surprises with regards to what may be introduced in this hearing. Now, the invoice, I'm gonna, allow you to proceed on without me receiving that other invoice, Mr. And Mrs. Peoples. But I may need that at a later time. So this is what's going to happen. Mr. and Mrs. Peoples, you're going to speak first, and then afterwards, you, Mr. Alvera. You started some of your defense, but I'll give you the opportunity to defend that once they're through, okay?
thank you.
Okay. Mr. and Mrs. Peoples, go ahead and present your case.
Okay, we had contacted American Roofing about a roof, replacing our roof. And the only stipulation was that the shingles would be black in order to correspond with the colors of the house now. The house now is black and white, more or less, black and white brick. And we wanted a black roof to coincide with the colors of the roof. instead, he came out and put some, look, he says weathered wood, which is brown and pink, I think. And with the brown and pink roof and then the black and white brick of the house, it's just a whole cluster of colors that don't go together. And that's all we asked him for was the black roof. And I tried talking to him and he wasn't going to change it. You know, so there's no need for us to really to talk about if he wasn't willing to change the colors.
And he also used different shingles that was agreed upon when we first talked to him. And he put some other kind of shingles on the house. When we talked to him about it, he came out to the house and he said that he was sorry for what he did and that he should have talked to us first. And he thought that putting a black roof on the house would make the house hot and all that. So he just basically did what he wanted to do after he got his $3,000. And he asked us if we would accept his apology. And we said, okay, but you still need to correct it. And he wasn't willing to do that. And so we sent him a letter and we offered to say, okay, since you put this brown roof on the house, either we can let it go like that and the $3,000 we paid you, that's it. We don't owe you any more money, or you can correct it. He didn't want to do either one.
And initially, $3,000 down payment was to purchase supplies.
Okay, hold on. Let me make sure I'm hearing you correct. You initially paid him the $3,000, right? And
yes.
Whenever y'all told him about it, there was a remaining balance. Is that
yes.
what it was? Okay, yes. So he told you that, look, I tell you what, you don't want to worry about paying me nothing else, but I'm not going to change the color back. Is that what I heard?
No, he didn't say anything about not paying him anything else. He still want his money, but he didn't want to correct his mistake.
Okay.
But he still wants to be paid.
So did y'all pay him? Did y'all pay him the remaining balance?
We paid him one time. We sent it because it was $180 a month after the $3,000 down payment, and we were supposed to pay the rest out $180 a month until the balance was paid. I did send him one payment, but after that, we decided that we wasn't going to send him any more money until we go to court.
Because he wasn't going to change the roofing.
So in total, you paid him $3,180 as of today.
Yes.
What was the agreed upon amount for total?
$6,000.
Okay.
$3,000 was down payment for materials, and to get it started.
Now we're getting into the financial breakdown, and this is where the math starts to matter. The total contract price was $6,000. They paid $3,000 down plus $180 payment, bringing it to $30,180 paid. Then they stopped paying once the dispute over color began. Here's what's legally fascinating: they haven't paid the full amount. So technically, the contractor hasn't been fully compensated either, yet they're suing for $12,000, which includes reimbursement and the cost of replacing the roof entirely. And here's the twist. The competing roofing estimate is $7,500, $1,500 more than what they originally agreed to pay. So now the judge has to determine, are the plaintiffs entitled to the cost of completely redoing the roof, even though the roof itself is structurally installed? This shifts the case from wrong color to what's the proper measure of damages. Would you demand a full replacement or accept a discount and move on?
So at that time, he could have purchased the black roof, black shingles. I'm thinking instead he had some shingles probably in supply, and he just threw them in there to, since he had the money. That's just my opinion.
Okay, so the estimate that you got from the other company How much was that estimate for?
7,500. 7,500.
And that 70, let me just ask you this, that 7,500, that was to do a total roof replacement, including everything that, you know, you might be out of, or, you know, any extras, because that's what some roofers do. I'm just assuming they charge a little extra just in case
Yes.
ride good or something like that. So $7,500 is a total roof replacement. Is that what
Yes.
they? Okay. And that's the new estimate. And what was it? Who was that estimate from?
It was from what's the name of it?
Castillo Roofing Solutions.
Castillo Roofing Solutions.
Could you could you just turn that around so I can see that? Bring it up, son, Mr. Peoples. Bring it up. Go up. Okay. Go up a little bit more. Okay, go up a little bit more. Okay, 30-year shingles. Go to the go to your left. Well, the other way. I'm sorry. Go the other way. Okay. And go down. Oh no, go up then. Go up. Go up. All right, go up a little bit more. And so go up. Okay, go to your right, son. Okay, so let's see here. So read that at the bottom. What does that say?
It says scope of work, put tarps around house, remove old shingles, repair any damaged decking at 75 per sheet after second sheet if needed, install synthetic felt, replace all pipes, flashings, and vents, install new 2x2 drip edge, prime and paint roof vents, pipe jacks, install ice and water shield on valleys, asphalt starter, universal starter course, ridge cap, standard profile composition shingles, install 30-year shingles on Corning Oak Ridge. Dispose of all trash, run magnet around yard, conduct final inspections.
Did it say anything about the color on that one?
No.
No, I don't see anything on this one about color. It says description, roof replacement, 30-year shingles. Price includes materials, labor disposal, and a lifetime workmanship warranty. Oh, sorry.
That you got from America Roofing, and I see why you went with America. It was $1,500 cheaper.
Yes.
And I see here pretty much it's similar to what you received as far as the work, but on yours, on the one that you received from America Roofing, they did indicate that the shingles are supposed to be black. Okay.
Yes.
Okay. All right. And so tell me, you know, a little bit more about your pain and suffering. Why is it that you feel like you are you should get an additional $7,000 something for pain and suffering?
The $7,000 is not for painting. Well, when he came to the house, we tried meeting with him a couple of times. And the last time he came, he insulted, I feel, my intelligence and my religion by bringing God into it and trying to tell me that my shingles was hot, that I didn't know what I wanted, you know. And I was insulted by that, and I asked him to leave because it's an insult to my intelligence and my religion. And the remainder is for court costs.
Okay. The reason why I asked that because as it stands today, you only pay $3,180, but you're wanting $12,000. So I was just trying to figure out where this extra $8,820.
This is the turning point. The judge is pressing hard on the damages calculation because courts don't just hand out money based on frustration or hurt feelings. He's asking the question every judge asks, show me the legal basis. The plaintiffs want $12,000. They've paid $3,180. So where does the additional $8,820 come from? Now they're arguing that the $7,500 estimate to replace the roof justifies that amount, plus reimbursement. But here's the tension. The roof isn't falling apart. It's not leaking. It's the wrong color. In contract law, damages are meant to put the injured party in the position they would have been in had the contract been performed correctly, not necessarily to give them a financial windfall. Is color alone enough to justify a full tear-off in replacement? This is where things get legally delicate.
Comes in. That's what I'm trying to figure out. Tell me why I should give you an additional $8,000. And I understand what you're saying about your feelings being hurt, but I'm looking for something other than that, Mr. Peoples. Go ahead.
Okay, because that's what it would cost us to get the roof replaced. Just
So
going by the other estimate from the other company.
So even though you didn't pay him the full amount, you're
I'm
wanting
sorry?
him, even though you did not pay him the full amount of the $6,000, you're wanting him to pay for a new roof, everything.
You know, Judge, if he'd have just done what he was supposed to do, that wouldn't be a problem at all. But personally, I don't really feel that he would come back and do a decent job. So we're gonna have to get someone else to do the job.
I understand you don't want to work with him. I'm trying to just make sure I develop the facts, and I need to, and I just want to make sure I'm hearing you correct. The reason why you're requesting an additional $8,000 is one, it's going to cost you $7,500 to get a new roof.
Yes.
And you want him to pay for that. And he, disrespected you.
Yes. And the other was reimbursement for what I'd already paid him.
Okay. All right.
Actually, we're not trying to get over anything. We just wanted black shingles on our house is all. That's all we wanted.
And what you're saying is that you don't trust him to come in and get the black shingles. Is that what you're saying?
Yes.
We don't.
Okay.
So we feel that he just baited us in and then switched the product. After he got the money, he switched the product and put what he wanted on there. Then tell us that we don't know what we want and that.
Yeah, because when he came over and he was apologizing and said that he should have talked to us first before he put that type of roof on the house, and asking us if we believe in God. And we were like, yeah, we believe in God. And do we forgive him? And I'm like, yeah, okay, I can forgive you, but you still need to correct your mistake.
Okay. All right. Let me anything else before I move on to the defendant, Mr. Alvera? Anything else I need to y'all want to tell me in regards to your case?
Yes, and this letter he sent us is one statement in there about the remaining balance. He was willing to come back and change the roofing, but he wanted the balance paid upon completion. But that wasn't what we had agreed on. We had agreed on $180 payments until it was paid off. But he wants to change it all now.
Mr. Alvera, here's your opportunity to defend yourself. Go ahead.
Thank you so much. Thank you so much. There's a lot of, I'm going to make a long story short. I didn't know nothing about Castillo's roofing solution. I didn't know nothing about it. They have been trying for us to work with them for way back, maybe a year ago. They start dealing with my son, Michael, and they request that if we can give him credit, and we used to have that. We used to give credit to the people, but we find out that it was too much hassle, and we stopped. And they keep coming to me, and they call me, and they come to my office trying to get the credit. And I say, no, we don't have no credit. We don't give no credits. Finally, I got convinced because I see that they good people. I say, if they good people, they will not do nothing nothing wrong. I'm pretty sure they will pay. So I decided to visit with them, and I say, look, I'm gonna do it for you guys, but please we don't want no trouble. We don't want no problems. Please, when we finish, you just pay you balance in good manner. And they accepted. They say yes. Also, I mentioned to them that they used to have a 3-tab shingle. It's a chip that is very cheap. I say, I'm gonna upgrade it to 30-year shingle. So they agree. And they mentioned that the neighbor have a roof that they like it. So and I apologize with them because the color that they wanted, I didn't put it on. I deeply apologize with them. And I say, well, in my mind, I thought it was going to be okay because we match the house that is in front of their house. And it looks very well. If you look at the house, the house look nice. And I understand that it was my mistake that I put the shingles that is on the front of the house is weatherwood. And it looks real nice, but they don't like it. And I say, look, I am going to give you 3 months off. You don't have to pay me for 3 months. Just pay me the rest and deduct 3 months. And they didn't accept it. And they want me to remove the shingles. I say, okay, I'm going to do that. And at the beginning, he accepted. He said, look, Joe, if you do that job, I am going to pay you not on credit. I'm going to pay you cash. I say, okay. That's what he has. What they told me at the beginning. And then me and Michael, we visit with them, and they didn't want us. They don't want us to do that. They say, no, we're going to go to court. We're going to go to court. I say, sir, we can work it out, the problem. And I went home, and in 2 weeks or something like that, I received a check. I received a payment. And I talked to my wife. I say, I think they understand, and they decided to go with the offer that I make. So deduct 3 months from what they owe. And then I hear that they sue me. That's the story. I was not aware that he was going to sue us. And I apologize with them. They accept my apology because in my mind, I told him straight. I say, I thought I was doing you a favor, matching your house pretty good, and I'm so sorry. But because I guess I make a little mistake over there, and I'm so sorry for that. And I am willing to work with them still. I'm willing to do. You judge and let me know what we can do to solve the problem. I want to be part of the solution because I love my customers, even though they sue me already.
Now listen closely to the contractor's defense. He admits the mistake. That's significant. He says he upgraded the shingles from 3-tab to 30-year shingles. He believed he was doing them a favor by matching a neighboring house. He apologizes. He even offered 3 months off payments. But here's the legal tension. An upgrade without permission is still a deviation from contract terms. Intent doesn't erase breach. The contractor also claims he offered to replace the shingles, but wanted the balance paid differently than originally structured. The plaintiffs say that changes the deal. So now this becomes a credibility issue. Who altered the agreement first? Who refused to compromise? And here's something subtle. The contractor keeps emphasizing goodwill and faith, but court decisions are based on...
I still love him because I'm a Christian man.
Okay. Mr. and Mrs. Peoples, you all sent him just want to make sure I'm hearing this correct. You sent him a letter on August 21st via certified mail with 2 proposed reasonable options. The first one was to replace the brown shingles with the contracted black shingles as originally agreed. And the second one would be allow you all to retain the brown shingles, but consider our $3,000 down payment as for payment for the project. Let me just ask you this, Mr. and Mrs. Peoples. If he were to agree to number 1, would you have continued making the payments as scheduled until the $6,000 balance was paid?
Yes, that was our plan.
Okay, and if he were to choose option 2, which is allow y'all to keep the brown shingles, but call it a wash for everything else, you would have accepted the brown shingles as is.
Yes,
With the $3,000 being paid in full.
and for him to continue with the workmanship that he guaranteed with the shingles.
That wasn't on your proposal. I was just trying to make sure yeah. Because all you said is that, hey, I'm giving you 2 options. Option 1, replace it, make it right, and we'll continue paying. Option 2, allow you all to keep the brown shingles, but consider the $3,000 down payment as full payment for the project. So if he would have chosen option 2, the warranty and all of that stuff would have been out. I just want to make sure you understand that, because that's what happens. They would have, it would have been a wash if he would have chose option 2. And if he would have chosen option 2, you would have accepted that brown roof as is, right?
Yes.
Yeah, that's what we said. So
Yes.
This moment is huge. The plaintiffs confirm under the judge's questioning that they would have accepted either option, replace the shingles and continue payments, or keep the brown shingles and treat the $3,000 as full payment. That admission tightens the case dramatically, because now the judge sees that they were open to resolution. But the resolution never materialized. What this does legally is show attempted mitigation. In other words, they weren't just trying to punish the contractor, they proposed solutions. Courts look favorably on parties who attempt to settle disputes reasonably before litigation. And now the judge steps away to deliberate. No jury, no drama music, just legal reasoning happening behind the scenes. What do you think he's going to do?
Okay. I'm going to put you back in a waiting room. I'll be back with a judgment. Okay.
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 Thank you so much.
Thank you.
Court's now back in session. Cause number J2V25-0691. Bobby and Frida Peoples versus Joe Ted Alvera, DBA America Roofing. In this case, after hearing both sides and taking into consideration everything that has been received by the court, I am going to rule in favor for the plaintiff. It's going to go as follows. Plaintiff will be awarded $3,180, the original amount that was paid to America Roofing. An additional $3,500 pain and suffering. Total judgment, not including court costs, $6,680. Including court costs, $6,824.
And there it is. The judge rules in favor of the plaintiffs, but not for the full $12,000. Instead, he awards $30,180, the exact amount they paid, effectively reimbursing them fully. Then he adds $3,500 for pain and suffering. That's the shocker. In small claims court, pain and suffering awards aren't automatic, especially in contract disputes. But here, the judge clearly believed the contractor's actions went beyond a minor inconvenience. Total judgment, $6,680. With court costs, $6,824, plus 6.75% statutory interest until paid. And if the contractor wants to appeal, he must post double the judgment, over $13,000 within 21 days. That's a serious financial consequence. Did you expect pain and suffering to be awarded in a roofing color dispute?
The statutory interest rate that will be applied to this judgment of 6.75% until the judgment is paid in full and satisfied. You, Mr. Alvera, you have the right to appeal my decision. If you do choose to appeal my decision, you would have to post an appeals bond of $13,648. It's double the judgment. You have 21 days from today's date to appeal the court's decision. If the case is appealed, it will be sent to the higher court, which is the county court of law. At that time, the case will start all over, meaning that it never happened. And you would have to provide, your proof to that county court of law judge. That being said, judgment favorable for the plaintiff. Court's adjourned.
Thank you.
Thank you, Your Honor.
This case is a powerful reminder that contracts are about details, and details matter. A roof is not just protection from the weather. It's a visual and financial investment. When the agreed-upon material and color are specified in writing, deviation, even with good intentions, can become a breach of contract. The contractor admitted the mistake. He offered compromises, but the judge ultimately decided that the plaintiffs were entitled to reimbursement and additional compensation for the distress caused by the mishandled situation. The lesson here? Contractors must follow written agreements exactly, and homeowners must document everything. Communication, clarity, and confirmation before installation could have prevented this entire dispute. Now we want to hear from you. Was the judge fair? Should pain and suffering have been awarded? Or should this have been resolved outside the courtroom? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.